Good evening, Mr. President, members of the board. You have on your, before you a memorandum that I prepared that's entitled Legislative Update. Let me explain what it is. At the end of every session, the Texas Municipal League prepares a rather exhaustive legislative update that summarizes every bill that was enacted that affects cities. This year, that legislative update was 125 pages long. Typically, it's about half that size. This session did not set a record for number of bills filed, but it nearly did. There were 7,541 bills, which was 50 less than the number filed in 2009. But in most years, 5,000 to 6,000 is the number of bills that are enacted. So it was a busy, heavy session. 1,437 of those bills passed. 336 of them affected cities. And I have summarized in that legislative update 65 bills that affect other political subdivisions, such as the Woodlands. Now, the good news is that, in my opinion, there was no bill enacted that directly affects your incorporation plans or efforts. There are some bills that affect you, obviously, a couple of them that I'm sure you've heard about. One you just heard about, House Bill 347, that extended the ban on unilateral annexation to all counties, is effective, but doesn't change the law as far as it applied to the Woodlands post 2017 and SB 6.
And Monty, can you go ahead and go ahead and stop with that, because I think Mrs. Lecoq asked a question. I will make a statement that we've not used annexation as a conduit or the energizing reason for this planning process. When the question was asked in the past, I clarified then, and I'll clarify again tonight. This process was restarted by the Woodlands Parkway extension and the major thoroughfare plans to extend Branch Crossing and Gosling north and Woodlands Parkway to the west. That was the conduit. That's what was stated publicly, and that has always been the conduit. We also subsequently said that the hurricane and the repetitive flooding issues from Tax Day, Memorial Day, and Hurricane Harvey would have been secondary triggers to if we had not already started the planning process. Annexation has never been the reason for this planning process. And the fact is, we've always acknowledged that 2057 existed. Now, the question as to where did I get the law didn't apply to us, you now have the man who told me that that previous 2017 legislation law did not apply to us. So I'll let him now speak to that opinion.
Okay. The question being, as I understand it, if the regional participation agreements went away for any reason, is the Woodlands still in danger of unilateral annexation by Houston or Conroe? In my opinion, that risk is greatly, greatly reduced, but not eliminated.
Why?
Because the argument remains that the city of Houston, the city of Conroe, and the Woodlands entered into contracts in 2007 that the legislature is constitutionally prohibited from impairing, that those contracts deferred annexation, and the argument would be presented by Conroe or Houston that, oh, we are now in 2057, 2037, whatever the year is, we are now guided by the law as it existed in 2007. And in 2007, unilateral annexation was still possible. There is a comparable provision in the law in regard to development agreements for agricultural land, wherein cities and owners of agricultural land in the ETJ entered into agreements to defer annexation for a period of time, up to 45 years under that statute. There is still recognized, and in fact, the General Counsel, TML, repeated it last week at the Texas City Attorneys Association conference, that there is still an argument that when those development agreements expire with the owners of agricultural land, cities may argue that they can go ahead and unilaterally annex based on the terms of those development agreements. Now, I've read your RPAs. I do not interpret them to say that the Woodlands ever agreed to annexation under any theory. But you can say that it deferred annexation. So I cannot promise that when the RPAs go away, that either Houston or Conroe might not make the argument, make the attempt, and it would have to go to court to be decided. Although I also predict that we're going to get some authority, get some guidance as we see those agricultural development agreements expire, and some city somewhere will attempt to annex that agricultural land, and that will be challenged, and that authority should help answer the question.
When will the first one expire?
Excuse me?
When will the first one expire?
There are dozens, if not hundreds of them around the state. I don't know. Some of them are probably going to expire within 2 or 3 more years. But they can have a life of up to 45 years.
Is there anything that would stop us from getting an opinion from the Attorney General?
You can certainly pose the question, seek an AG's opinion on that, certainly.
And so,
I mean, I think it would be a pure legal opinion. You know, the Attorney General doesn't like to give opinions on fact issues, but I don't consider this a fact issue. I would consider this a legal interpretation, and that may be something you want to pursue.
and so to what,
Monty, isn't there also a corollary to seeking an Attorney General opinion? That you may get an answer you don't like?
Well, that's true. You may.
Did I hear?
But an answer you don't like will give you more guidance than no answer at all.
Did I hear you correctly say that in the contract, it doesn't say that they are going to annex us in 2057?
It does not say
It just-
that they are going to annex
It just
you.
says we won't annex you until then.
Yes, annexation is deferred
Basically-
until at least 2057.
Once that expires and they have that option to do it, they no longer have the option because of this law. Because there was no agreement to be annexed.
That would certainly, that is the argument I think is correct. That is
that
the
again,
argument I
Brian?
think will prevail.
Because,
But I cannot tell you, don't worry, be happy,
right,
because of the change in the law.
because they said they wouldn't annex us until 2057, but once that contract expires, they no longer have the option because it's not in the contract to annex us.
Yeah, and I
That's
think
what it's
Monty's original read on this a year or two ago was that they would argue that the law in place to defer was in 2007. And so he basically says you can argue both sides of that argument. They would argue, if they chose to, that they only deferred because at the time of the law, they had the right. The other thing that we asked, and this is a legitimate part of the question, is, well, if there is no threat, what about our constantly paying 1/16 of our sales tax? Do we have the ability, since if the default doesn't trigger annexation any longer, then why should we continue to pay all this money? And I can tell you that when I went down and did the work with State Rep Keogh when he was in Austin to get our enabling legislation corrected, because in our original enabling legislation, we did not have it perfected to incorporate. There were gaps in the state code that we had to correct, and that was rectified in 2017. Every single sitting representative from the city of Houston asked the same question. Does this impair our regional participation agreement? You're still going to continue to pay? And remember, that's a 50-year remittance for a deferral that, if true, no longer exists as a threat. Then we have millions of dollars being paid to two entities that are being paid for no current future purpose.
Is it 50? I thought it was 99.
Oh, it's 99 years, I'm sorry, you're right. The deferred annexation is 50 years. The payments were for 99 years. I remember because I used to make fun of that as the Panama Canal and the Hong Kong of RPA agreements. 99-year terms.
Well, it seems to me that there would be very little risk in asking for an Attorney General's opinion. The worst place we could end up is right where we are right now. So it would seem to make sense to me that we should probably follow through on making a request for an opinion. Whether we'll get one or not, that's a different story. But, like I said, I don't see any downside.
Second. Is that a motion?
Could
It's not
I,
a motion, but no, it's not just
could I weigh
comment.
in on one thing here?
Yep.
We're talking about past, let's talk about future. Fast forward every 2 years, can this law change to go back to annexation?
Certainly. It's not likely to anytime soon, but it certainly can.
Right.
That would really strengthen the argument for the law being applied for when the contracts were signed, wouldn't it?
Well, I don't-
If you make the argument that, well, this is constantly amendable, this really, this could be amended in the next session, not likely, but, could be. It lends weight to the argument that the law that was in place at the time that the contract was made then becomes primary instead of,
yes.
that would really strengthen their argument pretty strongly, I would think.
Yeah, I think the emphatic statement, Monty, that you stated slightly less emphatic was that your interpretation of this when we first reviewed it was that the contracts made cannot be undone by the legislator.
Correct.
And that these contracts were signed in 2007, and which your opinion then was that new legislation would not impair them.
I don't think the legislature impairs the contracts, but I also do not think that the contracts grant
Right.
authority to annex, or that the Woodlands has agreed. The question would be whether.
That would be a different question, because we'd have to go back to the original putting the city or the township or the Woodlands unincorporated. Mr. Mitchell voluntarily added it to the city of Houston's ETJ. And so we don't know what that development agreement was in order to get the Woodlands original land mass added to Houston's ETJ, because it was not part of Houston's ETJ when this community was created. So that would be a further thing to look into, is what was the original Mr. Mitchell's agreement with the city of Houston to put this land mass, which is now our hometown, into Houston's ETJ? Was there a development agreement that he did actually, in fact, as the sole landowner, put into place with the city of Houston? I don't know if any of our historians here know.
The other question that needs to be asked is, while Houston never made a formal move to annex, Conroe did.
Conroe did.
Conroe did, and that was what actually triggered the legislation. So I think Conroe would also have a legal argument
Well,
that would be different.
If the law did roll back to 2007, then Houston and Conroe would both be required to put the Woodlands in a 3-year annexation plan. And that would probably be the point at which a legal challenge would be made, but they wouldn't be able to just annex overnight.
Okay.
How long would that
I'm
option?
I'm sorry, Brian, I'm just trying to get as clear as possible on this one,
Good luck on that.
I was going to say, in the absence of a solid legal, precedent. Sorry, Brian, go ahead.
How long after 2057 contracts expire would they have to annex us? Would they say, okay, day one, we're not going to annex you? Does that, okay, now all rules apply to this legislation?
If the 2007 law was in place,
No, I'm talking about after that. So the contract expires and they say, now we have the option to annex you or not annex
it's
you.
now 2047 or
Right.
whatever.
And then they say, we're not going to annex you. Is that it? Then after that, they need voter approval? Or is it like forever
Well,
that they had this contract and now they can use this contract going up?
I
until
would argue that 4 years would toll the statute of limitations.
So 4 years after 20,
If they didn't act in 4 years, you would.
so
you
by
would have lost that
2061 is
argument.
actually the end game for
Yeah. I mean, I would,
annexation.
In actual fact, though, Monty, what you're saying is that if the moratorium were to expire in 57, that Conroe and/or Houston, assuming that this law was still in place, would, 4 years prior to the end of the moratorium, could, at that point, move to place us in the pool in 4 years?
well, what I would expect them to do
Yeah.
is 3 years before
3 years
the
before.
expiration,
Yeah.
put you in an annexation plan. which is what the 2000 law would have required them to do, 2007 law.
Well, I think it would be wise to check all the original development agreements with the city of Houston that Mr. Mitchell had. As I understand, there was also, part of that was to get the Hardy Toll Road to come out to the edge of the Woodlands, was part of the incentive for it to come further than I think the original proposed toll road. So we do need to know if there is some originating development agreement that, I mean, all of our potholes say City of Houston. They don't say that for no reason. I guess some say City of Conroe.
You mean manhole cover?
Manhole covers, you're right, manhole covers. I don't know.
I know the city of
Heavy-
Houston has a lot of potholes, but they're not ours.
Yeah, the manhole covers, I misspoke. In order to identify if there is anything like these agricultural development agreements that may have been, in fact, actual contracts, separate and apart from the regional participation agreements, I do think that additional information has merit as we discuss this. All that set aside, as we sit today, regardless of which law is in place, we don't, and I don't, and this board, as far as I know, doesn't think that annexation is the basis for why we're even here tonight. We have emphatically stated that we don't believe we're in any threat of being annexed until 2057 based on the current agreements in place, regardless of the legal opinions of they do or they don't apply. And, you know, I think the issue was more infrastructure related and about the community and what authorities it wants to gain or not. So, you know, pros and cons can vary by individuals. The legal opinions are important. I hope, Ms. LeCloak, you're hearing from the man who stated they didn't apply to us, that is what he basically told us. I don't manufacture the responses, they are what they are. And, you know, that was his legal opinion that got you the statement that you got. Any clarifications beyond that on this particular old law, new law?
No, I have nothing further unless there are other questions.
So we do need to talk about the revenue caps as the new law that came out that will be long-term budget related.
What
And I
about
have-
Bruce's,
Yes.
I was gonna make the same motion Bruce did, I think, but.
Well, John, I mean, you know, at this point, I mean, I really don't have an issue with seeking the AG's opinion. I don't think it hurts us. Do you, Monty? Do you have any, you know?
I can't think of any downside. I mean, as Robin says, you may get an answer you don't like.
Yeah, well, I
But
mean,
what else?
but it'll give us clarity.
Yes.
Well, let's do this. Let's, as we go through these legal analysis,
Yeah.
let's start stacking so what we can have into one motion at the end.
Okay.
So we're not motioning through the middle of the entire agenda. So
How do we do that if we don't have an agenda item after executive
no,
session?
but this agenda item right here that we're on, right? So I'm going to write down right now, we're going to have a motion on an AG opinion, okay? We're going to also direct staff to investigate any land development agreements that may have existed between any of the cities and the land development company that may precede our RPA agreements, may have impact to the analysis, okay?
Well, I guess one of the benefits of having an incorporation item on each and every meeting is if there's something that comes up in executive session tonight, we can surface it tomorrow.
Yep. All right, so does that cover the two things that we thought we were going to be directing so far, and then we can add to it as we go through? Okay?
Now, as for Senate Bill 2, the revenue cap bill, again, I have no reason to tell you that it affects the Woodlands in any unique way or affects your incorporation. As you probably know, the bill modifies what was an 8% rollback rate and turns it into a 3.5% voter approval tax rate, and mandates an election, not just makes it possible, but mandates an election in any taxing unit jurisdiction that exceeds that 3.5% rate when taxes are
And
set.
let me just clarify again, that 3.5% taxpayer approval rate, is in fact 3.5% of the effective tax rate, which is actually, which actually constitutes the rollback rate, correct? Okay.
Yes, sir. Well, it's a very complicated bill. In fact, TML put out a 10-page summary of it that I brought copies of.
Okay,
It'll
so-
affect your taxing administration in various ways, but it does not change the law that exists in regard to incorporation and voter-approved tax rate that will be on the ballot.
Okay,
Okay,
when
so
you,
if the city, no, go, you go
okay.
ahead.
When you say it affects us in various ways, such as,
Well, the process for setting the tax rate, the number of hearings, actually, that's been reduced, but just a lot of administrative steps that you have to take. The bill doesn't go into effect until January 2020, but there is a deadline of September 30th of 2019 to submit a form. All taxing units must submit a form to the comptroller's office. That is a date that you're going to have to comply with, so that they can post every taxing unit's tax rate on the comptroller's website. But
Well, it
So the
doesn't,
city collected $100 in 2019. Is the idea that the city could collect no more than $103.50 in 2020, or how does it?
No, so this
that's
is-
a very simplistic way of saying it, because you consider the O&M rate, you consider the debt service,
It really applies to the property tax portion. Doesn't apply to sales tax revenue,
it's
hotel
property
tax
tax.
revenue. So if I wanted to summarize how this impacts the township is included as a entity that would require to comply with the 3.5% reduced rollback. If we looked at how that would apply to any of our previous budgets, it would not have impacted us in a single way, because we have been managing below or at the effective tax rate. And if we become a city, it would be the same. I think what Monty was trying to articulate is the incorporation ballot initiative requires a tax rate approval from the citizens. So in the initial vote, the citizens are voting for that initial tax rate. Subsequent to that, you would be under the
Capped.
same
You'd be
3.5% cap that you were as a township or as a city. Yeah, but it applies to the existing properties tax only. Does not apply to new properties added to the taxing area, does not apply to sales tax, does not apply to hotel tax, or for program fees or revenues derived from operations.
property taxes.
Property tax specific revenue cap.
that's my
So if the
understanding.
city had collected $100 in tax this year, and added $1 of new property next year, it could, during the year, it could in effect collect $104.05, roughly.
Except, John, that when you start talking about the effective tax rate, you have to take into account the appraisal creep, because the appraisal creep actually affects the effective tax rate. If the appraisals go up 3% and our rate stays the same, then your cap is about 0.5% then.
Yeah.
So you've got to keep that in mind. when
That's
you're talking-
absolute dollar. I'm talking about absolute dollars.
Right, so, you just have to realize that, it comes off the effective tax rate. That's where the rollback is set from. So there are more factors than just simply, what did you collect last year?
Okay, so I'm going to add to our list of things in a motion that'll come up later, that we also add the impact of SB2 to the projections that we're using in the incorporation study, and as well as in our 5-year budget process, which I think Monique was probably already going to do for us. Because we do need to see this modeled out as we look at our future projections to see, do we hit into these caps in the out years? I mean, the one thing that's interesting, our community's not going to grow. We are near build-out residentially and anticipate that to be finished in the next 5 years. And so the only thing we have in new property development in the out years is commercial development. So at some point in the not-too-distant future, we will not have new properties coming onto the tax rolls. So almost 100% in the future, our property tax is going to be impacted by this new law. And that would, I believe, eventually start to impact the budget process.
Can we get this, this memo, Monty, can we get this showing up on the screens and out front for people? Or is it out front already?
have copies?
I'm sorry?
Brought these as hard copies, we don't have this electronically. You're talking about that memo? that
Yeah,
we
like-
wrote?
We can have someone make
Okay,
copies,
certainly
though.
get it.
Someone run and make copies and, I mean, this is a public document, right?
As now,
Yes, yes. Let me also mention that SB2 has a unused increment rate that allows cities over a 3-year
to
period
bank.
to go above the 3.5 based on
Don't have
the increment between what they did the previous year or 2 years and 3.5. So you could, in that third year, go above the 3.5% if you had not done so. in the
Without a
previous year.
mandated tax election. Like I said, it is a very complicated bill.
It is, and for anyone interested, I recommend this 10-page, I believe, 14-page summary of the bill that is on the TML
Well, I will
website.
say that Don Norell and I went down to the meeting with the governor's office on these proposals. I thought this could have been addressed much easier and cleaner just by improving the appraisal caps, which wouldn't take a math genius to map out and carry forwards or anything else. I was told that that was a wrong-minded idea and that this much more complicated solution was the answer. But I do think the appraisal caps still would have been a much better way to get a control on the creep of increasing property taxes.
Well, the real problem is that, that it truly penalizes those jurisdictions that have lowered their tax rates instead of keeping them flat. There's obviously 3.5% of 20 cents is a heck of a lot less than 3.5 of 70 cents. So it's going to impact us. There's no question about that.
Any more questions on SB2? We talked about HB 347, which was the annexation. SB 1640, you want to talk about that, walking quorum?
That's the bill that attempts to fix the Court of Criminal Appeals opinion in the Doyle versus State case, which held that the provision in the Open Meetings Act about meeting in numbers of less than a quorum for the purpose of circumventing the requirements of the act was unconstitutional. So they replaced that in SB 1640 with a walking quorum prohibition, which basically prohibits you from participating in a walking quorum, a daisy chain of communications that results in a quorum of the governing body deliberating outside of a public meeting.
Is that in here, in
Yes,
your
ma'am.
document?
Yes,
Okay.
ma'am. It's
Oh, I see
it's
it right now.
summarized, and then
Yes.
it's in greater
Page
detail in
3.
the
Thank you.
TML update. Another open meetings or open government-related act is SB 944 that requires every temporary custodian, which is each of you, every governmental official that receives public records on their private devices, their telephones, their computers. If you transact township business using your private device, you're required to turn that information over to your custodian of public records, at least within 10 days of the time that you are notified that you must do so.
This is SB 969 you're referring to?
That was
944.
SB 944.
944.
Page 4.
If, for example, Monty, we were to get something on a personal email address, of a business nature, and we immediately forwarded that to the township email address, would that not cover that particular
should co-
requirement?
That should cover it. I anticipate that you'll see some standardized procedures
Yeah.
for doing that
Yeah.
come around. It's too early for them now, but
That
what
would
you-
place,
what
because
you
that would place the
described is-
information on the township server, which would be
That is the goal.
FOIAable.
So for instance, if you sent a text message saying to John Powers or someone, please call me, that then,
Well, I don't think just please call me
Okay.
would be, it would be Did you see what's on the agenda for Tuesday night? I am opposed to such and such and such and
Oh,
such.
okay. Yeah,
You
no,
know,
never
discussion of why you're opposed to it.
Yeah.
This sounds pretty similar to the training we received
It's
when we
really
joined the
not,
board.
it's
I mean,
really
we've always
not
been
a,
told, don't conduct
Yeah.
business, like via your Gmail account or, and sort of my practice.
Unless you
is-
work in,
it's
unless you
really
work in
not
the
a
federal
change in the
government,
law,
so.
in that if you have public records, public information on your private devices, it's still public information. Another open government related bill is HB 2840 that mandates that citizens be allowed to speak on any item that's on the agenda. And I'm sure we'll see different procedures for that, whether you want to deliberate first and then open the floor up to public comment, whether you want to allow it at the front end, you're still going to be allowed to set limits on the amount of time that citizens are given to speak. But the old rule that the only thing the Open Meetings Act did was give citizens the right to observe is no longer the law. It now gives them the right to speak as well. You've got various other laws that may or may not affect you, such as HB 2617 that says your fiscal year must be the same as the county's fiscal year. It probably already is, but if it's not,
I think that's a good question. I don't know that Harris County and Montgomery County fiscal years line up with each other.
I don't think they do.
They do not.
So we're in two counties.
How are we going to be in compliance with that?
Well, we won't. We'll be twisted.
I don't think the bill addresses that.
Of course.
But-
How could we
but-
think about all the variables ahead of
My
time?
prediction would be that it's which county the majority of the
Right,
township is.
which I think we do line up with Montgomery counties.
Yeah.
On Montgomery, you mean in terms of fiscal year?
Right.
We do not.
Oh, well, good. We're out of compliance already.
We have we're on a calendar year basis for our fiscal year. Montgomery County is an October 1st to September 30th, and Harris County is a March 1st to end of February.
Perfect.
Yeah.
And when does this take effect?
I believe it's
2020?
September 1st.
December 1st.
September 1st.
September 1st. So we're supposed to contort our budget process now to align to Montgomery County's fiscal year. More fun, Monique.
Oh, there's plenty of fun. The legislature has prohibited cities from, governmental entities, local health authorities from banning lemonade stands in the parks.
I wholeheartedly support that.
Yeah, I mean, it's government in action, getting down to what's really important. I know franchise fees have been an issue. There is one bill, SB 1152, related to franchise fees. It's not going to affect you now. It basically, it may give you some guidance on the franchise fee issue ultimately, and let me tell you why. What the bill does is allows
11:50.
providers of both telecom and cable to drop the lowest of those two franchise fees. Telecom is based on access lines. Cables is based on 5% of gross receipts. In most cases, the telecom franchise fee is going to be lower than the cable TV franchise fee. So the company that is providing it now only has to pay once. Now, the reason that may give you some guidance is because there is currently a case that was originally filed by the city of McAllen. It now has at least 40 cities that have joined it, that is challenging the small cell node legislation from the 2017 session. If you recall, that's a bill that essentially mandates that utilities be allowed to place small cell nodes on governmental facilities.
What was that
case,
bill? What was
excuse me.
that bill again?
Well, I don't remember the number of it. It was from 2017, but in essence, it says, city, if you've got a telephone pole and the utility wants to put a small cell node, for wireless communications, they are allowed to do that, and they must pay a legislative set fee to the city for each of those nodes. That is being challenged under the theory that it violates Article 3, Section 52 of the Texas Constitution, which does not allow the legislature to enact legislation that allows a city to give away money or to allow the use of anything of public value solely for the benefit of an individual, an association, or a corporation. The new bill that I just told you about that was enacted regarding cable and telecom is going to be added to that lawsuit, so that the argument is going to be that both bills, the 2017 bill on small cell nodes and the 2019 bill on telecom and cable, are both unconstitutional. And cities have hired some big guns, shall we say, to argue that case, and that may give guidance on the question of whether a city has the option of not collecting franchise fees for use in its rights of way, which I know has been an issue that has come up in the Woodlands.
And on that issue, you have already addressed it a couple times, but might be worth restating your opinion or your current understanding of the franchise fee collections and waiving of.
My understanding and my belief in the law is that a city cannot allow private companies to use public rights of way for free. They must, the city or whoever owns the right of way must be compensated for that use. Well, I say whoever owns it, it's really cities, because that's what Article 3, Section 52 addresses. So this is an issue that becomes important if you incorporate, not now.
So of the last 20 or so cities that incorporated in the state of Texas, how many of them had a franchise fee tax on day one? And how many of them had the statutory requirement that we list the costs of incorporating on the ballot?
The answer to your first question is 100%. The answer to your second question is 0%.
0%.
I know of no city that has ever had the tax rate on its incorporation ballot.
So what do you think the risk would be if the Woodlands incorporated without a franchise fee tax?
And
3 days later,
it's not a tax, it's a fee.
excuse me, franchise fee, and 3 days later, you give 72 hours notice, the then city council imposes a franchise fee at that time. So there would be a time period of 3 or 4 days where there would not be a franchise fee in place, and thus, you know, the Woodlands could present the all-in cost of incorporating on the ballot. What do you think the
Well,
risk?
in my opinion, it's one of those situations where the new city of the Woodlands would not be in compliance with the law, but who's going to complain?
For 3 days.
It's not going to be the utility companies that are getting the free use, nor is it going to be the citizens that do not have the franchise fee on their bill. Other cities may complain and object to your doing it. It's conceivable that someone could file an action for a writ of mandamus to order the city to start collecting franchise compensation. But
the concern I have with going I mean, are we going to talk about the item here in our packet with your February 20th, 2019 questions related to franchise fee, or is the intent to do that in executive session? Because I have a lot to say on this topic.
Okay.
Well, it's a question.
Well, the intent here is to give a general overview, and I think Monty has been providing general comments. We're not getting into the details of the how and why in the legal opinions. At this meeting, we would be doing that in closed session.
Well, I mean, he's,
It's a board determination, it's not my determination here.
I think the concern is we need to be careful we don't just sort of cherry pick the information we make public here. I mean, there's, I want to be respectful of the process, and so I'm not going to surface what all of my concerns are here just now, but I have concerns.
Keep in mind that the reason that this is on the agenda, split out the way that it is that we wanted to have an open session with certain items to discuss. We had a request from a director to review the legal opinions, so at a later point you can make the determination of where you go and what issues we discuss from there. but this was more the legal opinion was more an overview process rather than trying to make a decision on anything this evening on those items.
And so at our subsequent board meeting, be it in July or August, we can go through and select certain topics to place on the agenda.
Right. There's a number of issues that you'll need to make decisions on, and the board will need to determine if there's what information you want to no longer have privileged as information and really proceed in that way. Right now, what we do as a staff is the legal opinions that we have received are deemed privileged unless released by the Township Board of Directors.
Thank you.
So we would not get into that discussion on those in open session.
I guess my concern is similar perhaps as Director McMullen's is how can we, as residents of this community, if the election is called, to make a educated vote without everyone having the same information?
Well, I see. Okay, I wouldn't go quite that's not quite my concern.
Okay. That's why I qualified.
So, here's how I conceptualize it, Ann. I think that there are a number of legal opinions we have. From what I've seen so far, there are some that I'm unquestionably in favor of releasing as is. There's others I'm not sure about. And so I don't want to go on the record as saying I support releasing every legal opinion today, because I'm not there yet. There are certainly legal opinions I think we should release, and we can do some of this in executive session, and we can talk about it at subsequent meetings, but I have concerns about the franchise fee.
And I think part of what Director McMullen was just suggesting, the concern with whether or not the new law applies to the Woodlands or not, whether or not the RPAs are still enforceable or not, was advised not to be discussed in public, because now you're telegraphing to the cities of Houston and the cities of Conroe that you're looking to void a contract that has remunerations to them for the next 80 years. And as Monty has alluded to, they can change laws every 2 years. So you just invited them to do so by putting it out there that these are the questions we're looking to answer, versus the board in executive session saying, ask the same question, find the same answers, but now you just publicly declared you're trying to find, can you get out of certain things?
That actually wasn't what I was referring to either.
No, but there are other questions of legal sensitivity that are in the vein of what you're talking about. That example I just gave was one of them that had previously been discussed about why you don't put that out there.
Because if whatever is requested to the Attorney General is made public, correct?
Yeah.
Anything requested to the Attorney General is public information?
That's correct.
Yes.
Yep.
So I
Well,
think
but
just to-
hold on a second. Well, what we've asked for so far is simply the AG's opinion on whether or not 347 or 6 in the previous legislative sessions actually invalidates the section of the Constitution that says the legislature cannot make a bill that will invalidate an existing contract, and whether or not these contracts that were executed prior to the enactment of these new laws is in fact governed by that language or the current language. That, to me, we can't, there's no reason not to ask for that, because the worst possible response we would get is it doesn't invalidate them. It could come back and say, yeah, it does, and then the question is answered. If it does say it doesn't invalidate them, it still doesn't mean that, that it's a rock-solid opinion. It could still change. It could still change. But I don't see any reason not to ask for it in this particular case, because there's no real downside to asking.
I I think I agree with everything you're saying, and I think it's important to be precise here. I have not suggested that we
Oh, no,
invalidate
you
any
haven't.
agreements, or have not given that.
No, I'm not saying that either, John.
I didn't think you were, but.
No.
But
No, I'm just saying, I'm saying that, based on, what we're seeing here and the fact that there is still, because there is no case law precedent, none, at least that we know of, that, gets us, that gets us some clarity around this. So I don't see how asking the AG on this particular question puts us in any further jeopardy than we currently, have. And so, and it could provide some much-needed clarity to, what that situation is, especially in light of the 99-year requirement for continuing to pay the tax.
I think when it's come times to make the motion, let's be
That's
very
fine.
spec-
Well, that's
very
fine, John.
specific.
I'm with you.
I don't have any other bills that I wanted to summarize. I'll be happy to try to answer any questions about any that you may have questions about. Thank you.
Thanks, Monty.